Unit 4, Property Law. Chapter 16, Property and its Acquisition. Property is defined as the rights and interests of tangible and intangible things. For example, a house and land would be your property. Real property is in the form of land, buildings, and any other things that are permanently affixed to them. Most real property is tangible items. Personal property can either be tangible or intangible. Tangible are physical items, and intangible could be stocks in a company which are not physical items. Intellectual property is intangible property created by the intellect and includes copyrights, service marks, patents, and trademarks. Copyrights protect the expression of art. Owners of the copyright have sole right to reproduce, sell, perform, and display the work of art. A trademark is a word, mark, symbol, or device. An example of this would be the Under Armour symbol or the Nike mark. These are trademarks that are very popular. A service mark is a unique word, mark, or symbol that identifies a service. An example of this would be Mascara Makeup. It's a very unique name and is not used as a different brand anywhere else. A patent is the grant of the sole right to make, use, import, or sell. A patent is good to use for up to 20 years. Chapter 17, Bailments. A bailment is a transfer of possession and control of personal property subject to an agreement to return the property to a third party. A bailor is the party with possession of the product, and a bailee is the party that accepts the possession. There are two types of bailments. In actual bailments, bailees receive actual or constructive delivery of the subject matter of the bailment. Constructive bailments occur when a person already in possession of personal property holds it in such a manner that the law imposes upon him or her as a bailee's duty to deliver it to another. A bailee has different roles they play when accepting a possession of property. There are three things to take into consideration. There are three levels of modifying the care of property through legislation, contract, and a disclaimer. Chapter 18, Ownership and Leasing of Real Property. A lease is an agreement in which one party receives temporary possession of property for rent. Rent is a method of consideration given in return. An example of this would be charging people a fee for living on my property. Leasing property creates the landlord and tenant relationship. The landlord is the owner of the property, and the tenant is the person receiving the property temporarily. An eviction occurs when a landlord tells a tenant they can no longer use the property. Most often this happens because the tenant did not pay the landlord their rent. Chapter 19, Insurance Law. Insurance is a contractual agreement or arrangement that protects the people from loss. An insurer is a person that agrees to compensate in case of an accident of some kind. The insured is the party that is receiving the coverage. The potential of loss from injury, death, to damage are all examples of a different type of risk. Insurance is a part of an effective risk management program for a business or an individual. The general type of insurance intended to protect personal or real property brought by the perils such as fire, theft, and windstorm is property insurance. The type of insurance that people use for losses resulting from accident, chance, or negligence is casualty insurance. The most basic type of property insurance that covers the direct loss of property resulting from fire, lightning strike, or removal from premises endangered by fire is known as fire insurance. A variety of coverages may be provided by automobile insurance. The typical automobile insurance policy includes liability coverage, medical payment coverage, and collision and comprehensive coverage. Collision insurance protects against direct and accidental damage to the vehicle caused by colliding with another object, such as a tree or bridge, or possibly another vehicle. The last type of insurance we're going to talk about is life insurance. Life insurance is a contractual agreement under which the insurer promises to pay an agreed amount of money to a named party upon the death of a particular person. Chapter 20: Wills, Trustees, and Estates. The administrator is the person who takes charge of an interestate's property. This representative uses the property of the deceased, called the interstate, to pay all debts, including the cost of the administering the estate. The remainder of the estate will then be distributed in accordance with the state's intestacy statute. A will is a legal expression, usually required by law in most states to be in writing, by which a person directs how her or his property will be distributed after their death. A holographic will is one that was written entirely by the descendant's own hand, signed by him or her, and not witnessed. Holographic wills are recognized in about half of the states. A nuncupative will, or oral will, is recognized in some states if proclaimed during the maker's last illness or by service personnel on active duty. However, the will must be witnessed and reduced to writing within a short time frame. For various reasons, people may wish to transfer the immediate control of some or all of their property to another party with instructions on how it is to be managed. When the transferee of the property is a separate legal entity, a trust has been created. A trust can be created for any legal purpose. The legal entity that has the title to the subject property is known as the trustee.